I don't know. After hearing him calm and talking about the tether story, it's probable.
Just go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
What's going on? This is Colin. How's everybody doing? Happy Thursday. I had to figure out what day it was. Thursday. It's still Thursday. Hope everyone had a great Thursday. Thank you for being here. Oh, I've got some good clips. We start with Judge Simpson, then we go to Judge Ricke for the main event. What's on the thumbnail? It's a tough case. Very opinionated about it. So yeah, we'll get to it. And then we finish up with Judge Mercer. All right. Hey everybody. How's everybody doing? I see everyone in the chat rolling by. Hope everyone's well. Before I hit this play button, you already know what to do. Do what my brain. I can't brain tonight. Hit that like and subscribe and do your jump kick backflips. All right, let's go.
Morning, Your Honor. Marcia Crater on behalf of Ms. Roper. Ms. Roper, can you please state your name?
Candy the Roper.
I don't know if the prosecutor did.
I did, Your Honor.
Okay, thank
I
you.
would also note, is the court in receipt of a violation report?
I am.
Your Honor, and I know this is a large docket. I respectfully request the court to pass this matter such that I can speak to her regarding the bond violation report and go over it with her. I just started that process. She doesn't have access to a phone and she's living at Miller Manor. I've been unable to discuss this matter with her until she had come to court today.
Well, here's the problem. She was supposed to report over to community corrections. I gave her leeway the last time to get herself over to community corrections.
I did.
Pardon?
I went.
You have the report?
I have the report, Your Honor, and it does, I believe, indicate she did show up.
She didn't test.
I
didn't have the money to pay.
They would have tested you.
She
You didn't report.
test
You
me.
did not report back to test. What did I tell
told me
you?
to call the next day.
What did I tell you the last time? I said no more missed tests. Remember me telling you that? I didn't hear a response.
No, I don't remember you telling me that, sir.
You don't?
Because I hadn't been there. So you told me I had to go over there. I didn't have the $12 that
Miss-
were there with me. I didn't have the $12 that day. And she said to call her the next day if I could get there. She
And did you
reminded-
call?
Yes. I told her I didn't have the money to do it.
You didn't report. I don't know that there's much else to discuss.
Did you guys notice where the buff lip is standing? He moved there right quick, real fast. Right when he said you were supposed to report, he got the hint and went right behind her.
Ms. Crater, what do
Your
you
Hon-
want to do with the proceeding?
Your Honor, at this point, Your Honor, I would request an adjournment of the PCC in this matter to see. I'll just request the PCC be adjourned for as short as time as possible, Your Honor.
Probable cause conference will be adjourned to next week, February 8th, 2024, 9 a.m. Anything you want to say regarding bond?
Your Honor, my client does have support in the community. Avalon Housing representatives are here. They have supported her. She did.
Would have helped her arrange for testing.
Avalon has reported to me, Your Honor, that they are not able to financially support her as far as that goes. She did go over to community corrections. She completed the intake and was put on a random indicator according to the report. She was, as according to the bond violation report, she was instructed to submit. She stated she did not have the money. She was, okay. And she was told to submit.
Whoa. Look at the next line.
She was instructed to return the next day. That's what I was going, is that the line you're
In the
referring to?
next sentence, and she
She
failed to
be
do
there.
so.
Mhm.
She told me just to call if I couldn't.
There has been no contact with Mr. Roper since intake.
The report is accurate on that, Your Honor.
Anything else you want to say?
Your Honor, I'm concerned with if she's incarcerated, her ability to continue with services through Avalon Housing.
Ma'am, I told you to appear, and you had 2 previous missed tests. You gave me the story the last time. I was serious about your reporting, and I told you no further missed tests. You missed a test. You didn't do it. You didn't even cooperate. You didn't go back in terms of even follow the instructions that they gave you going back. Defendant's bond is hereby revoked. Defendant's remanded.
Thank you, Your Honor.
All right, real quick. Watch Judge Simpson just snap his neck real quick and look in the direction of her. I'm wondering if she says something as she's walking out. That's what it looks like. They don't bring it up again, but you guys let me know what you think.
Court calls the case, People versus Ronald Ray Wilson.
Yeah, what do you think? I mean, I don't know. Something happened, otherwise he wouldn't have done that. Anyways, MB, thank you so much for the $10 super chat. I appreciate it. Yeah, KCC's a friend and a friend of the channel, so anything I can do to support her that helps her, yeah, I'm always game for that. But thank you so much for the super chat. That being said, super chats. If anybody's so inclined, my link tree is in the description. Those actually do help me a little bit more because YouTube doesn't take anything from it. Just saying, if that's what you want to do, it helps me a little bit more. I don't care either way, though. Just saying. Thank you. Okay, main case. This case is, yeah, it's not good. It's not good, but yeah, we'll talk through it. We'll talk through it. It's a pretty long one. It's about a 25-minute hearing, so we'll talk as it goes through. And people, her soaps, Peeps' soaps. If anyone has not tried or ordered any of her soaps yet, you should. They are amazing. I got some for Heather for Christmas. Peeps gave me one as a bonus, and yeah, it's called The Perfect Man. So it's perfect for me. Yeah. It's good though. It's good. All right, let's go. Thank you, people.
Resumes proceedings in State versus Linden. Greenwood case 23 CR 61. Ms. Gillette, Mr. Linden, Mr. Gary appearing as before. Court has now been sent and has now considered an alcohol and drug evaluation and a treatment completion certificate that was issued by clear direction. Court is familiar with these documents and finds the pre-sentence evaluation to be sufficient and in accord with Kansas law. We are ready to proceed further. Counsel, the pre-sentence report has been disseminated to both parties. Is there any objection by the state to the criminal history which is stated in this report?
No, Your Honor.
Any objection by the defense, Mr. Gary?
No, Your Honor.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to the primary count is criminal history score I, and the court will proceed further accordingly. Ms. Gillette, are you aware of any legal reason why sentence should not be pronounced in the Linden case here today?
No, Your Honor.
Mr. Gehring, are you aware of any such legal reason?
No, Your Honor.
Mr. Linden, are you aware of any legal reason or any other good reason why the court should not proceed further with your sentencing?
No, Your Honor.
Court will proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other type of sentencing related motion to take up. Does the state have any such motions to pursue?
The state does not, Your Honor.
Does the defense, Mr. Gehring?
No, Your Honor. Thank you.
Are there any victims or members of the victim's family who desire to address the court in relation to this sentencing?
Judge, we have Ms. Linden here.
Very well. She'll go ahead and unmute herself. And would you first state your name?
All right. This is the ex-wife, I believe. This is the victim. This is kind of graphic. It's a little tame, but she does use some graphic words. Jedi. Thank you, Fred. Thank you, Jedi. Yeah, Fred's cat gets everywhere. It gets everywhere. You guys, thank you so much.
Lori Linden.
What is your relationship to the defendant, Brian?
I'm his wife.
All right, very well. Do you have a statement you wish to make to the court?
Yes, I do.
You may proceed.
Thank you. I'm here today to tell my story about my abuser's violent behavior and the impact it's had on me and my family. I am here as someone's mother, daughter, sister, aunt, and a friend that was the victim of a terrifying attack by their abusive husband. I know a lot of women are too afraid to speak out against this type of abuse that goes on behind closed doors. So I want to stand up for myself and those who are unable to speak out. I am grateful that the district attorney pressed charges against my husband because looking back at my state of mind after the attack, I may not have asked for those charges because I was in a state of shock. However, I feel disappointed that the aggravated assault charge was lessened to criminal threat since he actually held a gun to my head. It is even more upsetting that the attempted rape charge was dropped, but the DA said that she didn't think she could get a conviction in Greenwood County. It's very disturbing to me in this day and age that most people think that it's acceptable to try to rape their wives. Most people know my husband as the fun party guy, telling his exaggerated stories, making people laugh, and being the good old boy. But there is definitely a darker side to him. In the 10 years that I've been with Brian, he would drink at least a 12-pack of beer or hard alcohol every day. On weekdays, he would start drinking during his long drive home from work and continue to drink until he went to bed. On weekends, he would start drinking when he woke up and would drink all day until he went to bed late at night around 3 a.m. So basically, if he wasn't sleeping or working, he was drinking, and he used his drinking as a crutch to deal with everything. For these reasons, I had to set sexual boundaries because he would want to have sex with me when he was drunk and he was heavy and the sex was sloppy and could be painful. So I would put him off by saying that maybe we could do it in the morning, hopefully when he was sober. This boundary was put in place several years ago, but I didn't make it known to him that it was a boundary because if I would have, he would have gotten angry and I was worried about what he might do since he's had anger issues ever since I've known him. These anger issues, along with the alcohol abuse, have affected our marriage and our family get-togethers. He would often drink so much he would pass out during our family holidays at our house. Many times he would take his words to the extreme and would often talk about wanting to hurt or kill people that he was mad at. When he got belligerent, he could be verbally abusive to me and always wanted people to know that he was the one that controlled our relationship and that he was very demeaning to me. Many friends and family members have witnessed this behavior, like the day he was drunk and humiliated me in front of my daughter, her boyfriend, my nephew, and niece when I asked him to pick up some food that he dropped on the floor. Even his son from a previous marriage would often talk about how mean and abusive he was to him as a child, and his other daughter doesn't have any contact with him because of his behavior. His anger was so bad that people stopped coming to the house during football games to avoid seeing this behavior. He would get loud and angry at bad calls and say the players should break the opponent's necks or knees or some other violent thing, and I would have to watch the game in another room when it got that extreme. His anger affected his work as well. He didn't like confrontation and would often leave work before the shift was over when someone made him mad, since he didn't know if he could control his anger and didn't want to get fired. He loved to brag about how tough he was and the fights he and his family would get into with others, stating that if they couldn't find someone to fight, they would fight each other. Now looking back on all this, I realized that his alcohol abuse and his anger issues made him a ticking time bomb, and it was only a matter of time before he would do something violent to me. In the past, he had physically tried to force himself on me, but nothing like he did on this night. This night seemed like any normal night together, but I didn't realize how much he'd had to drink when I went to bed. The police report said that his blood alcohol level was 0.178, over twice the legal limit, and this was a few hours after he'd stopped drinking. I went to bed before him and fell asleep, but about 2 hours later, he woke me up in a drunken rage, saying he was leaving me because he was angry that I didn't have enough sex with him, even though we usually had sex once a week for the last 10 years. He was packing his bags, and when I tried to convince him to stay home because he was drunk, he got angry and decided he would try to force himself on me against my will. This was not consensual. When I told him he was too drunk to drive, he got mad and came over to my side of the bed and lunged at me, holding me down with his body. And then he pulled my underwear off me while I tried to hold on to them, causing them to tear. Then he pulled down his pants and held me down and tried to force himself on me while I screamed at him to stop over and over again, asking him what he thought he was doing. As he held me down, he squeezed my wrists so hard that I thought he was going to break them. But I finally fought him off of me, and that's when he grabbed a gun that he had put in his sweatshirt pocket, and put it to my head. I grabbed the barrel of the gun and pushed it away, but then he stepped back in a shooter's position and pointed the gun directly at me. I asked him if he was really going to shoot me, and I remember seeing the rage in his eyes, and I thought that he really might pull the trigger. I was very scared. Several seconds passed, but eventually he did put the gun down and left the room. This is when I got up and got dressed and called the police, and he was arrested. When the police arrived at the house, they found the gun on the ground in the circle drive in front of the house, so apparently he dropped it on his way out to his car. They could still see the imprint of the barrel of the gun on my forehead and saw the red marks on my wrist, and took pictures and searched the house for the torn underwear. But apparently he had enough forethought to take them and hide the evidence of what he did. Unfortunately, this is not the end of my story. The attack has impacted my entire family. In fact, my dad stayed with me for the first 4 months after the incident while I filed for divorce and found another place to stay, because he was worried about what Brian might do in another drunken rage after he was released from jail. I was worried about that too, so I decided to move far away from our home. But I still relived the night of the attack on a daily basis, and finally decided to seek domestic violence victim counseling to help me cope. The divorce and the move have been very devastating to me. It's been hard to deal with the fact that the person that I loved, that I was in love with and trusted and built a life together for the last 10 years, had done something so violent to me. I was committed to being with this person for the rest of my life, and we were making plans to move closer to his work and family, and now all of that is gone. Even though there's a protective order, he continues to try to hurt and intimidate me by contacting my family members, like my Uncle Greg, my Aunt Sharon, my future niece, ex-sister-in-law, and several other family members and our friends, to manipulate the story to try to convince them that I'm the crazy wife and he's the good guy, something that he did with his other exes. But the truth is, he's a habitual liar and narcissist, so he wants to ensure that he controls the story and looks like he's the victim. I also feel like he's lied so much to his own family that they don't want to talk to me, so I've lost them too. And it's sad because I know they're going through a difficult time and I can't be there for them. He's even gone to desperate lengths to contact the outfitter that killed our dog and bullied our family for years in an attempt to try to use him in court as a witness to discredit me, but the case never made it to trial. It also affected our adult daughter because she was so shocked and upset by his attack on me and is working through this trauma in her therapy sessions. When she reached out to him after he didn't try to take responsibility for his actions. He blamed me and told her that I was crazy and that I was the one that actually abused him in the relationship. She knew this was absurd because she knew what our relationship was like for the last 10 years and had lived with us for part of it and knew how he acted when he was drunk. She hates that he's spreading lies about me, about what happened, since he told her that he didn't even remember what happened that night. Also, within 2 months after the attack, he's posting Snapchats of his new relationship with another woman and other pictures were posted on Facebook of them together with his family and friends. He even participated in a dad bod contest, drinking and dancing around with his shirt off in front of a large crowd. So it seems like he has no remorse for his actions and doesn't care about her or me, and was just trying to find another woman he could manipulate and control. So in the end, I am very upset that he did not take accountability for his actions and pled no contest instead of guilty. He still sees himself as the victim in the story and his other past relationships, so it's doubtful that he will ever change his behavior. I know he will never apologize for what he did to me because of his narcissistic nature, but I hope that he will reflect on what he did and try to be a better person. I hope he seeks professional counseling for his distorted views of sex versus love and gets educated on marital sexual consent, because he always told me that he would divorce me if he didn't get enough sex. I also hope that he seeks counseling for his drinking and his anger issues for the sake of his new relationship. Lastly, I hope the court considers all of the things I have mentioned today regarding the long pattern of abusive behavior by Brian Linden and makes the appropriate decision based on the impact that it's had on me and my family. Thank you.
Thank you, Ms. Linden.
All right, I didn't want to pause it while she was talking. I wanted that to be one clip. Man, you guys with the super chats and the cats. Fred, cat ran across the keyboard. Jedi, you don't even have a cat. That was Fred's cat. Evelyn, thank you so much. That was a really nice message. Thank you for the $20 super chat. I appreciate it. And yeah, I'm glad you've been watching and you enjoy the channel. That's awesome. And Sparkle Poots comes in with Fozzie's cat ran across the keyboard. The cat's getting around. You know what's funny? The last clip, the one I have after this, I can't remember. There's an animal that's brought up, and I think it's a cat, which if that's the case, it's going to be hilarious. It's either a cat or a dog, but I think it's a cat. Susie Miller for the super sticker. Thank you. Legal Fiction, your cat made you do this. Get with the cats. Fred again on his second account. Fozzie's cat ran across the keyboard, changed accounts, and sent this. All right. J Hart with the cat. I actually laughed out loud when I saw that. J Hart, that was funny. Yvette, dang it. I fell for the old knock on the door, open to see who it was, and the cat ran in this. Thank you. Allergic to cats, keeping them away. Thank you, Sly. Then Fozzie's cat wants to challenge me to Fortnite. All right, let's do it. Let's do it. And then Sparkle, I don't know how the cat grabbed your underwear, but just keep it away from this guy on the screen. Keep it away from that guy. And yes, the defendant is with his attorney in the bottom left, and I don't remember who said it. Her affect did seem a little off, but she was reading from something that she wrote. So, that's I believe what she said too. But I see what you're saying.
Are there any other persons who desire to address the court in relation to this sentencing? Family members? Court finds no others. At this time, the court will ask for recommendations from counsel regarding an appropriate sentence for Mr. Linden, beginning with Jill Gillette on behalf of the state of Kansas.
Judge, this is a 3-count conviction, the first count being criminal threat. It is the primary count and felony in this matter. It has a standard term according to the sentencing guidelines and his lack of criminal history as being 5, 6, or 7 months. We'd recommend the standard term of 6 months. There is up to 20% good time credit and 12 months post-release supervision. Under the Kansas sentencing guidelines, it is a probation case based for 12 months of probation. Count 2 is driving under the influence. It is a Class B non-person misdemeanor. We'd recommend the 6 months to the county jail. The count 3 is domestic battery. We would recommend, again, it's a Class B non-person person misdemeanor, person misdemeanor, and it carries the term of up to 6 months in the county jail, which we would recommend. Because there's a felony that would have KDOC time, we'd recommend that.
Are they coming up mid-stream? If that's the case, then I must have clicked that on accident. I am very sorry. I will check that setting. But yeah, they usually just come up at the beginning. I've never set what is it called? Mid-roll ads. I've never set that. But I've always just had the basic YouTube, whatever the default settings are on. So maybe, I don't know. I didn't, but you know what? At the same time, when I was monetized the first time, I didn't do many lives. So maybe there's a difference. I don't know. But I'm sorry if they're coming up mid-video. I do not like that.
Accounts can run concurrent so that if he services underlying, he would serve it at KDOC. He scored out for court services probation, and it is recommended that he attend a DUI victim panel, and for the domestic battery, complete batter's intervention, and that he have the standard cost and standard terms of probation. In addition, there is a DUI fine. This scored out as a first-time DUI. That carries a fine of $750 minimum. This is his first felony, so there would be a DNA database fee of $200. There is court cost, and this is felony court cost, $193. There is booking and fingerprint fee of $45. He has done his own drug and alcohol assessment, so the drug and alcohol assessment cost would not apply in this matter, and his attorney is retained, so there'd be no Robinson findings in this matter. There are optional domestic violence fees if the court orders those in this matter, and the correctional supervision fee of $120. There is 3 days of jail credit as well to be awarded in this matter, as he spent 3 days in jail.
Anything else, Ms. Gillette?
I think that's everything I have to cover, Judge.
Very well. Mr. Gehring, your recommendations regarding an appropriate sentence?
Thank you, Your Honor. Just to clarify real quick, Jill, are you not recommending probation on the misdemeanor counts?
Well, they recommended probation along with the felony.
Okay, I just wanted to make sure. Your Honor, we are asking also that you follow the plea agreement as set out in the acknowledgement of rights form. Obviously, by the victim's statement, this alcohol played a huge role in what happened in this. Mr. Linden has taken steps to address that issue. He has entered into the program that was recommended for him and has successfully completed that program. So, like I said, Your Honor, we would just ask that you follow the agreement as was set out by the parties.
Mr. Gehring, what about the meanness that comes out when he's drinking? That's not all attributable to alcohol, is it?
I would say that that's probably true, Your Honor. And obviously, if the court were to follow the agreement and follow the recommendations to the state, obviously the batter's intervention program should have a great effect in addressing those issues. That's something that we thought about doing beforehand, but it's always an issue with getting into that program without an order of the court, in my experience. So he understands that's something that's probably necessary and appropriate and beneficial for everybody, and he will be willing to follow that.
Very well, and you're obviously retained counsel, correct?
Yes, sir. Your Honor. Yes, sir.
Very well. Thank you for your recommendations. At this time, the court will address the defendant, Brian Linden, personally and ask him if he has any statements that he wishes to make in mitigation of punishment or anything further that he would like to present to the court. Mr. Linden?
No, Your Honor.
Very well. Court will pronounce sentence at this time. Court hereby establishes count 1 as the base sentence in.
All right. How long would you guys sentence this guy for? You heard Jill, I think she asked for 6 months. The defense didn't really argue a whole lot. How long would you guys sentence this guy for what the victim said? I'd be very interested because you might be shocked at what happens.
This case, for the offense of criminal threat, a severity level 9 non-drug person felony in which the defendant has a criminal history score of I, thus placing him in grid box 9I. The court hereby sentences the defendant to the aggravated term of 7 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to post-release supervision of 12 months. The court has considered but declines to impose a fine on that particular count. Regarding count 2, for the offense of driving under the influence, Class B non-person misdemeanor, the court imposes 6 months in the Greenwood County Jail and runs that time concurrently with the time imposed on the felony. The court also imposes a fine of $750. For the additional offense of domestic battery in count 3, a Class B person misdemeanor, the court imposes 6 months in the Greenwood County Jail, runs that time concurrently with the time imposed on counts 1 and 2. The court, rather than impose a fine on that count, does order this defendant to enter into and successfully complete a batterer's intervention program, provide sufficient proof to his supervising officer. Court notes that in grid box 9I, this is presumptive probation under Kansas law. Under Kansas law, unless there's been a motion filed for a departure sentence, the court must grant probation in this case, and will do so here. Court does order the defendant to an initial term of 12 months probation to be supervised by court services. Court services supervision is deemed to be appropriate because of the medium risk score on his assessment. Conditions of probation will include observing all laws, reporting to an officer as directed, obtaining an anger management evaluation and abiding by the recommendations of that approved anger management assessment. That must be obtained within 60 days of today's date. He shall not possess or consume alcohol or illegal drugs while on probation. At his CSO's request and at his own expense, he shall submit to random breath, blood, and urinalysis testing, perform any community service work that his officer requires. He shall successfully maintain employment throughout his probationary term, notify his CSO within 48 hours of any change in employment, residence, telephone number, or email address, have no contact with the victim in this case, submit his DNA to the KBI data bank and be responsible for the $200 cost of the test, abide by any curfew or travel restrictions imposed by his officer, follow all standard conditions of probation, not have in his possession firearms or dangerous weapons, avoid disreputable characters and places. The court will be assessing to him not only the DNA fee and the $750 fine, but also a misdemeanor docket fee, felony probation fee, booking fee, $100 domestic violence programs fee, and will require the defendant to pay a minimum of $100 a month on these obligations, starting with the calendar month of January of 2024. Court also orders the defendant to attend and successfully complete a DUI victim panel program during the term of his probation. Court has considered the victim impact statement that's been made by the victim in this case. Quite frankly, the court has been made aware of the utter severity of the incident which took place in this case, which not only involves intimidation, it involves intimidation with a firearm. This could have turned into a deadly situation, and only for the grace of God, apparently, it didn't. This is not your typical domestic violence. This is not your typical driving under the influence case, and in the view of the court, it's not the typical criminal threat. Again, There is no departure motion before the court, so the court is not authorized at this juncture to order a prison sentence. So the court will, in the alternative, order as much incarceration time as this court can under Kansas law. The court does impose a 60-day jail sanction in this case, effective immediately. The court is required to and does credit 3 days previously served in the case against that 60. He has 57 more days to serve. I will require the defendant to report to the Greenwood County Jail by no later than 6:00 p.m. this evening to begin this period. I would ask the court services officer assigned to this case to monitor whether he reported on time. If he doesn't, I'm going to ask the court services officer to file a request for revocation of his probation. Because the court has imposed this jail sanction, the court does realize that it's unrealistic for him to obtain his anger management evaluation and have that completed within 60 days. I will extend that to 120. The court has already dealt with the issue of jail time credit. He does have 3 days to be credited against his time imposed as a condition of probation, and should be reflected by the sentencing journal entry in this case. At some point in the future, Mr. Linden, you may have the right to seek expungement of this offense. Certain statutory limitations do apply to each one of the counts. If you have any question about your right to seek expungement of one or more of these offenses, you can ask your attorney for further advice, and I'm sure that he can provide it. Mr. Linden, under certain circumstances, a criminal defendant may have a right to appeal a conviction to an appellate court having jurisdiction. And if they are unable to pay the cost of an appeal, the defendant may request the court to appoint a lawyer to represent him on appeal and that he be supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, you, the defendant, Mr. Linden, have 14 days after this judgment to file any notice of appeal with the clerk of the district court of Greenwood County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, and that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. This court will also make the observation for the record that the defendant has never taken responsibility for his actions in this case. He did not plead guilty in this matter, but rather a no contest plea, which he has the right to do. But combined with the fact that when he was asked to make a statement today, he can't even formulate the words, "I'm sorry." All of that has been weighed by the court in making its ultimate determination here today. I will remand to custody starting at 6:00 tonight of Mr. Linden to the Greenwood County Jail for 57 more days before he can be released.
May I have 30 seconds with my client, Your Honor, before we close the record?
Yes.
Thank you.
All right, while we're waiting for them to come back, more super chats. Thank you guys. You guys are awesome tonight. I appreciate it. Sly Delish, allergic to cats. Yeah. Watch out for Fred's cat. Thank you, Sly. Fred, again. This is Fozzie's cat. Oh, I already read these. I thought there was more. Oh, I skipped up. This is Fozzie. My cat told me to let you know he doesn't like ads in the middle of videos. Yeah, we don't like that. I'll check on that though. Hi, other cat was female. I'm the male cat. We need more Jessica Blanche. We do. It's just not easy to find her. It's not. I know, Fred. I know. And Sly Delish.
Thank you,
Sorry
Your Honor.
so
I was
much
just
about
speaking with Mr.
Fred's
Linden
cat.
about, obviously the court has ordered that he maintain employment. I was going to consider asking the court to consider authorizing him for work release during.
Where does he work?
Well, that's the problem is his work is not local, so I don't think that's probably an issue that's going to work.
It's not local. That request would be denied.
Would the court consider house arrest as a sanction so that we can keep him employed? Or I understand, Your Honor, that
there are implications to criminal behavior, and in this case, the behavior is flagrant enough that if it's a natural implication that he has employment-related consequences, so be it.
I understand that, Your Honor. In regards to his lack of making a statement, we had talked about that beforehand. His difficulty speaking in a setting like this, and he would like to apologize to Ms. Linden for what it's worth at this point. We understand that it may be too little, too late, but he would like to say that.
Lori, I'd like to apologize. Sorry for any stress or anything, the hurtful things. I never meant to hurt anybody in the family, especially you. Deeply sorry. Hopefully one
Mr.
day.
Linden, you've got some issues you still need to work on. And that's what this probation was all about. You can avoid prison by working on those issues and completing your probation requirements. And I truly hope that you're successful in all those areas. Ms. Gillette, is there anything else we need to address?
Judge, I have 2 questions. Did you order the misdemeanors concurrent or consecutive to the felony?
All counts are concurrent.
And the other one that I have is on count 3. I need to know if you are designating that to be a domestic violence offense. It'd have to be to the trier of fact. This was a plea. And if yes, if it was used to coerce, control, or punish the victim, and is this designated as a domestic violence case?
It shall be so designated. The court makes the finding that based on the presentation to the court that this is a domestic violence designated crime. Furthermore, Ms. Donovan, what direction would you give Mr. Linden in 57 days when he's released from jail?
Your Honor, excuse me, Carrie Seeley is going to be supervising this probation, and I can provide a phone number. It is 620-953-2013.
Mr. Gehring, did you have an opportunity to get that written down?
I did, Your Honor. Thank you.
The court will order the defendant within 1 business day of his release to contact Ms. Seeley at that number provided.
Your Honor, in the event that Mr. Linden is able to find employment locally, would the court consider authorizing work release at that point?
I guess we'll cross that bridge when we get to it, Mr. Gehring. I would not absolutely preclude it.
Okay.
Very well. If there's nothing further, the Linden matter will currently be in recess, and this meeting may be ended for all at this time.
Oh man. Yeah, I knew that when the sentence was dropped that people were going to have a lot of issues with it in the comments. Yeah, I don't know why I did that again. Debbie's right. I was reading what Debbie was saying. The judge had guidelines to follow. There wasn't a departure filed. Couldn't go above the guidelines, so it sounded like he did the max that he could. So you can't blame the judge. And then you look at the prosecutor for the charges. Prosecutor may not have had enough evidence to put more charges. But man, yeah, the comment section is gonna blow up on that video when the video is over. But thank you everyone for who super chatted since the last time. I think for the super chats. Legal Fiction, thank you. I can tell you're a Law Talk with Mike fan and my wiener. Yeah. Cat jumped on your iPad and your wiener. Yeah. What is it? I'm trying to remember what the clip actually says. I know it says the cat jumped on my wiener, but yeah, I don't remember the full clip. Anyways, thank you. Sparkle Boots, damn cat. Cats everywhere. All right, last clip. And like I said, I think there's a cat involved in this, which makes it so much better. It might be a dog, but I think it's a cat. It's one of the two. All right, let's go.
Kia Riley. Miss Riley, come on up. Miss Riley's coming up in 23-818 MM. Did Miss Bremer discuss Miss Riley's case with you?
Briefly, Your Honor, and it looks like she was able to make contact with or at least we got the victim impact statement returned And there was a request for restitution.
Ms. Riley entered a plea of no contest on the same date as Mr. Dixon, which was January the 8th. Ms. Riley wanted to be sentenced and get it resolved. The problem was that Ms. Bremer had not heard back from the alleged victim, and the question was whether or not the state was going to offer a PTI. So we explained to Ms. Riley and her mother that it was possible a PTI would be offered if we set the sentencing off a few weeks and give the state more time. And so Ms. Riley and her mother both said if the offer might get better, that they would just wait and get sentenced today. Is that right, ma'am? Did I explained that correctly? So she's here. It was either going to be probation or PTI, depending on what Ms. Bremer found out.
So there is a request for $900 of restitution. If she's willing to agree to that, then the state would agree to offer her a PTI.
Do we know what that is for?
Yes, Your Honor. It says $300 for dental work and life management, and then it says $600 for lost wages.
Yeah, is there any documentation to support that?
She just sent in a victim impact.
Thank you, Legal Fiction. That is right. Now I remember it clearly. Yeah, thank you. It was good. Patricia, no, I had a dog for 16 years. I had a full-bred Australian Shepherd. Got him at 6 weeks, and he passed away at 16. It was about 3 or 4 years ago, and I haven't got another animal since. But yeah, I've been thinking about it a lot lately, so I think I'm about ready for another one.
Statement.
Okay. So it sounds like she's trying to make money off of a criminal case, which obviously is not appropriate without some documentation. So there's two things we can do. If the state wants to offer the PTI, we can do the PTI reserve on restitution, have a hearing on restitution, or if the state doesn't want to offer a PTI, then we can try to get it resolved with probation.
The Ms. Bremer's comment just was that it looked like a significant battery. If she's claiming she had to get dental work as a result of it.
Without any documentation.
Without any documentation.
Where's Ms. Bremer at?
She's in trial with warrants.
Okay. So what do you want to do, Ms. Jeffcoat? Ms. Bremer is familiar with these cases, and yet she's sitting watching a trial instead of handling her own cases, which is bothersome to me, but I can't do anything about that.
We'll offer probation today, Your Honor.
Okay. So the state's offer is probation today. So what that means is you still have the same options that you had before. Yes, ma'am. You can come on up.
I just have a question, Your Honor.
Yes, ma'am.
Because I do have a packet myself that I have to send in for being the victim in the crime. This young lady was still incarcerated when we were here on the 8th. She was incarcerated. She was still incarcerated, and I'm just not understanding.
So I don't think Ms. Jeffcoat is familiar with the case. The prosecutor in the case has chosen to go to another courtroom for some reason instead of handling this case. But what Ms. Jeffcoat, what you missed was prior to this alleged victim is a defendant in a case involving you, correct, ma'am?
Yes, she stole my dog.
And so during the process of the dog recovery is when this young lady is accused of committing battery on this alleged victim.
Okay.
So there's a pending grand theft case. Is that person a juvenile or is it in the felony court? The alleged victim here.
My first instinct was to say sorry for keep pausing, but yeah, I'll always pause for dogs. Mine was, what was the breed? A blue merle, I think. So it looked gray and white, but it had like the blue shimmer to it with the blue eyes. And mine was named Foster. And yeah, Foster would try to talk to me all the time. He was smart. He knew how to let himself out to go to the bathroom, and he would come back inside. He didn't know how to close the door. So I would, come out of the bathroom, the back door would be open, and he would just be laying on the floor or the couch. It was like he had to go to the bathroom. So he just let himself out, went to the bathroom, and came back in. He was a wild dog. He was awesome though. Oh, why I haven't paused? I did have another super chat. I always have a hard time saying your name. You know that we've talked about this before. So I'll just say AS. How about that? My cat software. Here, I'll bring it up. My cat software and dog hardware husky punched me. All right. Well, you know what? Your animals got a super chat for me. So thank you. But thank you. I appreciate it.
I believe she's in felony court because the paperwork, I should have brought it with me, my apologies. But it also said she had narcotics on her.
So I think that's correct. I think that, so y'all have a pending felony against your alleged victim. And Ms. Jeffcoat doesn't know any of this because
sir.
she's covering for Ms. Bremer today. So, so here's your choice, okay? If you want to withdraw your plea, you got to turn that off.
I'm sorry.
Just turn it off. Okay, it needs to be totally off. So here's your choice, Ms. Riley.
Yes, sir.
Given the fact that they're requesting a bunch of restitution they have no documentation for, Ms. Jeffcoat's kind of in a difficult position because she's being asked to cover someone else's case and the case is not fully prepared as it should be. Remember the last court date, I said, why you've had plenty of time to contact your alleged victim. Well, now the alleged victim was in jail is part of the problem. So choice number one is to say, I want to start over. I want to withdraw my plea. I want to start over because you have no prior criminal history, correct?
Correct.
Yet the state's not offering you a PTI. And the reason they're not is because there's this restitution that the alleged victim's asking for, but they don't have.
Because I remember the lady that came up, I remember her saying something like kind of going off on the defendant. There was some kind of wild speech. Maybe I forgot, but in my notes for the video I had it, so maybe I got the wrong one because this is kind of boring. You're right. It is the last clip, and there's only about 7 minutes left. But yeah, I'm not entertained either, Debbie. Don't worry.
Documentation for it yet. She may be able to get documentation. She may have several $100s worth of dental care. I don't know, but she's also charged with a felony herself. So choice number one is to say, I just want to start over, withdraw my plea, and let's go back and let's start from the beginning. I'm going to ask for the public defender's office to represent me and go through the case from the beginning. If you take that choice, you're going to have to come back to court. Choice number two is to say, I want to go ahead and get resolved today. I don't want to continue this any longer. I don't want to have to keep coming back up here. If you take choice number two, I'm going to sentence you to probation. That's all I can do. And I'm going to reserve jurisdiction on restitution. So there's going to be a hearing on restitution. If you take choice number two, it's not a PTI. It's not a first offender program. It's probation. The state's not offering you the first offender program for the reasons I've already said. Okay. Ms. Bremer, did I miss anything?
No, Your Honor, you didn't miss anything. If the defendant was arrested this day of the battery and she's still at the jail, I don't think she's going to be entitled to any lost wages because that would be.
That's a good question. When was the defendant in your case, ma'am, the one lady that stole the dog, she was arrested? Okay. Do you know her name?
What's her name?
I guess Quadisha Johnson.
I can't understand what you're saying.
Quadisha Johnson.
Johnson?
Yes.
Okay. Let's try to get Ms. Shapko a little more information. Johnson. Quanisha?
Yes, sir.
Let's see what I can find on that name. That would be interesting, Ms. Jeffcoat, she's requesting lost wages for time that she was in jail, if that's what's happening.
Yeah, because that's not going to be as a result of the crime. That's going to be the result of her arrest.
There's no recent case on anyone named Quan Johnson. I just searched Quan because I didn't know how to spell it. Q-U-A-N is what I tried. So let's check the calendar for Judge Garcia's court. When did she have felony court? You say she just got out. When did she have felony court, Gary?
I could step out and make a phone call.
It's okay. When did Judge Garcia have felony court? She had it this week.
We had the last time we had
trials this week.
The last time we had felony court, Your Honor, was on the 16th of this month.
Okay, thank you. Let me check the docket for the 16th. And let's see if there was a Johnson on that docket. There is a Quanisha Johnson, Quanisha Nicole Johnson. But this is a 19 case. So it's a VOP. So let's see. The VOP mentions a petty theft and a possession of controlled substance without a prescription. So she's got a new charge of that, And let's see if I can find the new case, 23-677 CF. That's going to be it probably. So in that case, first appearance, let's see the complaint. What date was Miss Dawn? What date was Miss Riley's complaint? 12/15. Offense date. Okay, the complaint in this case, Ms. Chefcoat, says 12/15. Hartsfield is placed under arrest.
Okay.
Excuse me. Did it say Hartsfield?
Yeah, I think that's.
It's under the Quenisha Nicole Hartsfield in the complaint. That's why it's causing
So those are the same offense dates, right, Your Honor?
same offense dates.
So-
And she, at first appearance, she was set a bond by the judge, no contact with Shakia Riley, which is you. So
Oh.
she had a condition, no contact with you, and there's no indication she ever posted bond, and she's still in jail. So I'm not sure how she had lost wages when she went in jail.
Yeah. So Judge, I'm sorry to change directions on you, but while she's here, if she still wants to resolve it, the state would agree to a PTI and reserve restitution for the dental work if she can prove it. I don't know that she'll be able to prove it, but the state's not going to seek any restitution for lost wages when she's in jail.
Yeah, this is not what I remember. I am sorry, guys. This is a boring case. I have, just to defend myself, I've got a folder with 30 gigabytes of raw court footage, so I can't remember every clip. So I put notes. So I write notes for everyone, so I don't have to go back and watch every single clip, because I put together hour-long videos, right? And watching an hour-long video before I publish it would take a lot of time that I don't have. So, yeah, that's my excuse. I just skim through it quickly, and I usually find the parts where I need to edit out, or when I switch tabs. You guys see me do that a lot. I usually find them. I don't always find them, but yeah, my notes were not good on this one. That's 2 in a week that were just boring, snooze fest. But there is only about 3 minutes left of this, so Judge King had a soft sit today. Judge King did? The soft sit that I have on the schedules for tomorrow. All right. Thank you, Lisa. I'm going to go back. He doesn't delete his content very quickly, so I'm going to go back and look. The only case that I saw, the only hearing I heard, I actually just skimmed through it, so I don't know. Okay, thank you. I'm going to go back and check that out. There was a soft sit today that I think 3 channels covered, so I didn't grab it. It was like an hour-long case. It was long, and everyone else grabbed it before I saw it, so yeah, I didn't grab it. But yeah, okay, there's 3 minutes left. I'm going to peace out, let the video play out. Thank you, everybody, for coming. We will be hanging out in Discord after this if you guys want to come out and say hi. Thank you, everybody, for your super chat. 40 minutes. All right. Yeah, if you edited it down, it was 40 minutes. There was a break in between where they heard a couple of other hearings. So from my timestamp from start to finish, it was about, okay, so I lied to you. I did lie. I did grab it, but then I deleted it. It was like an hour and 5 minutes from start to finish with the cases in between. But yeah, I just deleted it because I saw it on everyone else's channel. Probably should have just told the truth. I don't know why I lied. All right, because I'm not playing it is why. Anyways, I'm going to stop rambling. Let this boring clip play out. Thank you, everyone, for your super chats. Thank you, everyone, for hanging out. I appreciate it. If you guys are bored, jump over to Discord afterwards. We have fun there. All right, until next time. Bye.
Okay, ma'am, I think that was your whole point. Ma'am, do you have any questions about that before your daughter makes a decision? No, she's an adult, but I want you to make sure you have any questions.
I understand solely about it, and
Okay.
I just would like the same information about the dental work.
Okay.
Because it wasn't.
Well, and I don't know how she's had a chance to go to a dentist if she's been in jail.
Right.
So, Miss Riley, this is the first offender program that Miss Bremer explained to you last month was a possibility. It basically means that it's just like probation, except when you get through with it, the case is dismissed. The downside to a PTI is you still got terms to do, you still got things you got to complete, and if you don't do those things, you can go to jail. So you've got to take it seriously. But the good news is that if you do it, everything you'll have the case dismissed. It's for basically it's for a year, but at the end of 6 months, if you've done everything you're supposed to do, then the case can be dismissed early. The court costs and fines are $270. Were there any other conditions, Ms. Jeffcoat? Was there any kind of anger management or anything?
Yeah, no contact and anger
No
management.
contact with the alleged victim and anger management counseling, which is a typical condition of battery cases. So, Ms. Riley, do you want to do that, participate in that PTI program with those conditions?
Yes, sir.
Okay, we'll show your case referred to the PTI program. I'm going to need you to see Mr. Goodson here, Ms. Riley. This resolves the case. I am reserving jurisdiction for 60 days on restitution. Like Ms. Jeffcoat said, if they want restitution, then they're going to have a hearing and show that they're entitled to it. And they may be able to, but it would be, she can't collect lost wages if she got arrested on something of her own doing.
I have a question about the lost wages. She has to have a job in order.
Absolutely.
to have-
Yes, ma'am.
Okay,
And she would have to be able to go to work she would have to have a job and she had to miss work because of this case, because of her injuries.
okay,
And she missed work because she's in jail. That's not the same thing.
I looked up a lot about her and I asked around because we're new here. We're from New Jersey and she picked up my dog out my yard and put him in a bag because he's very small. And since this, it's just been ongoing about my puppy. And it's really getting aggravating.
Well,
And she didn't have a job. The people where they found her at with my dog popped up out of her jacket. Where they found her at, the people say she'd been sleeping around.
but just my suggestion is you just focus on Miss Riley, make sure she does what she's supposed to do, get this case behind her and get it dismissed, okay? So Mr. Goodson, see Mr. Goodson here. Yes, sir.
Thank you so much.